第二節呢就
We now start with the second session. We'd like to welcome the EOC for accepting our invitation to come and attend our meeting today so that we can have an exchange of views. We have Mr. Herman Poon, Chief Legal Counsel, and Dr. Ferric Chu, who is the Head of Policy and Research. Welcome to you both. So, the two representatives from the EOC can now make an opening statement, and then the floor will be open to members. Which one of you would like to speak? Yes, I'll speak first. Thank you, Madam Chair and members. The EOC welcomes the bill. We support that it be enacted as soon as possible. The current SDO would only prohibit sexual harassment of employer against the employees and also between employees, and there is no prohibition of sexual harassment of a customer harassing a service provider. And as you can see, the stakeholders generally support this amendment, and that would also extend to aircraft, even if it's outside Hong Kong. So that's also in line with some legal principles governing that. And I can see that there is a submission from the Law Society which says that it agrees to this point. So in principle, we support this amendment. In our earlier discussion, we also talk about the third gender, whether they would be protected by the amendment as well. We believe that if we interpret the law properly, sexual harassment protection should not distinguish between the gender status. So whatever the sexual status or gender status of the victim, so long as he or she is sexually harassed, he or she should be protected. As to the sex or gender status of the victim, whether or not this status is recognized or not by law in Hong Kong, the person should be protected. So even if the gender status of the individual is not protected by law right now, or even if it's not recognized by law in Hong Kong, if the person is sexually harassed, the person would be protected. Even if there are certain terms that carry a gender implication, it does not affect the protection of the law afforded to the individual. And with regard to the expressions or words, well, usually we would now use the neuter gender, and we believe that using neuter genders would be more appropriate, well, for words or expressions that were drafted in the past. They might carry a masculine or feminine meaning. And then we are dealing with a part of the SDO, and that's about sexual harassment. And if we were to change it here without changing the other parts of the law, then that would not be consistent. So that's why we have to strike a balance.
I think it is more preferable to have the amendment comprehensively, and then we can be sure about the impacts. Earlier on, mention has been made about employer liability. In principle, we believe that employers are duty-bound to provide a working environment free of sexual harassment. As the law stands, the employer has got the duty to take reasonable measures to prevent its own staff causing sexual harassment. Otherwise, he has to be made liable. The law as it stands does not require the employer to take reasonable measures to guard against sexual harassment by a third party, say, for example, clients. We believe that we should consider the case in this direction. We have looked at the overseas experience. In some countries, they have got provisions to say clearly that for customers harassing employees, it is against the law. An employer has to take reasonable measures upon receiving a complaint to prevent sexual harassment from happening again. In New Zealand, this is the case. In some states of Australia, say for example in South Australia, they do have this provision. But then at the federal level, yes, it is an offense for customers to harass employees, but there is no provision to ask employer to take reasonable measures. In the case of the UK, there isn't any clear provision to say that it is an offense for customers to harass employees. But then in 2008, they introduced a provision to say that employer has the duty upon receiving a complaint to prevent against this happening again. But then in 21.3, the provision was repealed. So it seems that it is not unanimous in overseas countries. We are embarking on an overall review of all the anti-discrimination ordinance. So this part will also be taken up. Last week, we completed the exercise of collecting public views. A lot has been referred to us, and we are now in the stage of collating the information. In the middle of next year, we expect to present a report and come up with follow-up recommendations. As to the question of defendants who are outside of Hong Kong, well, if we want to take legal action against an offender or a defendant who is outside of Hong Kong, the risk and also the legal procedures involved are more complicated than in the case of the defendant being in Hong Kong. Say, for example, whether the defendant is subject to the jurisdiction of the Hong Kong courts. It depends on the question of whether there is mutual assistance agreement between that foreign jurisdiction and Hong Kong. Of course, in the case of an overseas defendant being subject to the jurisdiction of our courts, and if he's willing to come here to answer the charge, then the problem won't be great. But then if he refuses to do so, then maybe the plaintiff has to get a judgment in a local court, and then via the mechanism of mutual legal assistance, then action can be taken. It all depends on the agreements between the two jurisdictions. In some cases, there isn't really much that can be done. For this sort of risk and difficulties, it is not confined to sexual harassment related civil cases. It is true in other civil cases as well. So it depends on the features of individual cases. For the UC, we haven't had the experience of dealing with a defendant who is outside of Hong Kong. It is a very specialized area, and if necessary, we have to get legal advice from someone who has expertise in this field. Madam Chair, I would like to pause here, and maybe members have got questions, and I'll try my best to assist. Thank you, Mr. Poon. So this is the time for members to have exchanges with the EOC. For members who put down their names, Mr. Lee Chet Yen, Mr. Tang Ka-Piu, Sid Ho, Raymond Chen, four of you. Mr. Ho would like to have more time, so I will suggest 4 minutes. Helena Wong, the fifth one. Lee Chet Yen. I would like to thank the EOC's representative for telling us about the overseas experience. I think one of the main concerns is employer liability. Yes, the UC is consulting the public on this matter, but then for this bill, I want to know if the UC would like the government to cover employer liability as well. Let me say this again. I'm not talking about criminal liability. Maybe the UC can tell us about the overseas experience. I would rather focus on the preventive action on the part of the employers. So UC, please tell us what you think. Would you like to take this opportunity to cover employer liability as well? Yes, you're still in the process of consultation. By the time you finish with the consultation exercise, the bill would have been enacted, and then we don't know how many more years we have to wait until another opportunity presents itself. So would you suggest to the administration to cover employer liability in this exercise? Would it make it sort of more comprehensive? You see, of course, we would like to enhance the safeguards, but then to be practical, the overseas experience varies as to how the provision should be drafted. We haven't got a final decision. We also want to complete the consultation exercise early, and we expect to come up with some recommendations in the middle of next year. So it would only be next year that they can come up with recommendations at the earliest. So, yes, I know. So there are two options. Either we wait for you to complete your exercise, but we've been told that this matter can't wait, or you want to do it more quickly. Now, I don't know if the administration can give an undertaking. That is, we enact the bill first, and then you try to move an amendment ASAP. But of course, we need to queue in the line. We can't help. But what about the timing, the timetable? Can the administration give a reply as well? Say if the UC comes up with a recommendation next year, and if you have time, is it possible to have a second amendment bill in this session? Within this term, I mean. Now the UC is still working on the consultation. The earliest to make recommendations will be next year. Now, maybe the Bills Committee itself need to have time to deliberate on it. So if we talk about ASAP, how much time would you need? At least 1 year, I think. Administration, Mr. Poon from the UC has said that we need to work on this issue. Well, from the first session of this meeting, you can see that it isn't just about employer liability. There are other aspects that have to be addressed as well. Mr. Poon has said that we may want to be pragmatic. So let's move step by step. Let's enact this bill, and then we await the consultation exercise to be completed. We get the recommendations, and maybe we need to have another round of consultation, and then we can take the legislation as a whole. Would that take a long time? Madam Chair, it depends on the outcome of the UC's consultation. Next, Mr. Tankapio. Thank you, Madam Chair. Question for the UC. 500 plus cases of sexual harassment have been reported, and then many have not been pursued. And I want to know from your experience. You have said that 250 cases have been discontinued. What about the employer's role? I want to know whether you can work through guidelines. among the 500 plus cases, does any of them involve the employer? And then one of the deputations has not come, but I've been asked to say something on their behalf. Now, we have a local person being a tour escort, and then he or she will take a group of Hong Kong tourists to go overseas. Maybe the group members are over-friendly and have bodily contacts. Once they have landed, then the law doesn't apply. There's nothing that can be done. I want to know if we can work other than through legislation to make sure that the tour escorts can be protected. Yes, you have talked about 19,000 tour escorts. 60-70% of them are males, but then the others are also females. So can anything be done? I hope they will feel that they will still be protected. Now, of course, if the tour members are non-Hong Kong residents, then it will be difficult to pursue the matter. But we are talking about a tour escort taking care of a group of Hong Kong tourists. I agree that we should enact this bill first. Otherwise, if we start to involve the case of transsexuals, then there will be objection, while others will say that we are being too conservative. So it's better to enact the bill first.
Mr. Poon, thank you for your question. With regard to the 500 plus sexual harassment cases, according to my impression, two involved customers sexually harassing the service providers. In the end, we were not able to deal with those cases, and we had to discontinue the investigation because there's no legal basis for us to take up a case with the relevant parties. With regard to tour escort or tour leader, all right, if we are Hong Kong people and if we are on board of a flight and if there is sexual harassment, then after the amendment bill is enacted, then Hong Kong will already have jurisdiction over those parties on board of a flight, and therefore we can deal with that. But then after the aircraft has landed, then if you look at the territoriality principles, then we may have to take up the case through the local legislation. But then is it possible for you to focus further on the protection that can be afforded to these practitioners because of the specific circumstances and so on? All right, they might be checking the rooms with the customers, and if they were sexually harassed by the customers, then what happens? All right, we can issue some code of good practice code after the enactment of this amendment. Indeed, there would be a need for us to be more specific in issuing guidelines to the public. So that's something that we will be doing. But then after the aircraft has landed, as to what happens next, well, that would already cover the issue of territoriality. And at present, we are not inclined to deal with that because it also involves the local jurisdiction and whether we can have a jurisdiction over others' jurisdictions. Ms. Sito, I'd like to follow up on a point that I made in the first section. During the past few years, the EOC received some 500 plus cases. How come they were only able to provide legal assistance in 16 cases, only 3%? So what's the reason? That's point number one. Second, well, you've just completed a consultation exercise, and the questionnaire was very complicated, close to some 80 questions, and some would involve the powers of the EOC. and also some existing anti-discrimination laws. So you're adopting this 1 in 4 or 4 in 1 approach. In fact, that's a major operation. So with regard to the 4 in 1 legislation, and also before the controversy is over, will you consider that with regard to any one of the existing anti-discrimination ordinances, will you be asking the administration to amend the individual ordinance first before you embark on the 4 in 1 anti-discrimination legislation? Because in that one is a very controversial case. Mr. Poon? Yes, I'll first answer the question about law review or legal review. We have already collected all the feedback, and we are now in a process of collating the information. And as the member pointed out, it's very controversial and it's a very complicated issue, and we will have to set priorities as to which issues will be dealt with first. And as the honourable member just said, for the less controversial issues, maybe they can be given priority. I think that's a very high there's a very high likelihood that we will be dealing with that in accordance with the controversy that might arise. Well, about sex discrimination, in fact, for many years, our awareness has been enhanced, and there is not much doubt about this, other than the principal equal opportunities officer who try to coach people into answering questions or into answering no for women being harassed, or else the awareness in the community is already very high. With regard to the RDO, there has been a lot of misgiving about that, and if you try to deal with everything after all is settled, then that would also delay the process of enacting the less controversial amendments. So please consider that with regard to SDO and also the Family Status Discrimination Ordinance, they should go first. Yes, that will be considered. And also for the provision of legal assistance, how come it's only confined to 3% of the cases? Well, out of the 500 plus cases, 136 cases were successfully conciliated, and 83 were unsuccessful. And out of the 83 cases, and there were 255 cases of discontinuance, and out of those cases, there was a chance that they could apply for legal assistance. And then fourth, we had 105 cases which lacked substance, and they could also apply for legal assistance. But then during this period of time, in terms of the actual application for legal assistance, we only received 40. And for the 16 cases in which legal assistance was granted, well, that was out of 40 cases. So 16 out of 40. So it's about 40%. How about the remaining 24 cases? Were they among the 83 cases of unsuccessful conciliation, or were they out of the beyond the 12 months time bar, or lack substance, or whatever? So can you give us the details with regard to the 24 cases which were not granted legal assistance? Can you give us a breakdown of the types of cases? And if the 24 were out of the 83 that were unsuccessfully conciliated, then that would give us a very big question mark. All right, you were not able to conciliate, and then you will have to give us the reason as to why they were not legally assisted. So can you provide us with an answer in writing? All right. Next, Raymond Chan. Thank you, Madam Chair. Just now the EOC representative said that if the neuter gender could be written into the law, that would be the best. But we also have to understand that when compared to other pieces of legislation, if it's written in, then that would not be consistent. All right. If you were to make a suggestion to the administration, then would you recommend that they write it in or not? And of course, if we can apply it to the whole set of legislation, so that for all the words and expressions with a gender implication, if that could be revised, then of course that would be the best. But then that would take 10-20 years before the LRC can come up with its recommendation. So I don't know how we should deal with that. And also for people of neuter gender, all right, that's a practical issue. For example, in some cases, the passport would write X gender on it. So that would apply to some expats or foreigners. And then under Section 7 of the IGCO, according to the administration's interpretation, it says that it would include the neuter genders, but then that would not apply to this SDO. So does the administration agree with the DFJ's, or does the EOC agree with this interpretation by the DFJ? Well, I understand the justifications for the DFJ's interpretation. We haven't yet got a case involving a person of neuter gender. We don't know how to deal with that yet. But then our own view is that by neuter gender, even though the gender status is not recognized by the laws of Hong Kong, but then in itself, it doesn't mean that the law does not apply to them, or that the law does not afford any protection to them. We believe that whether or not is regulating their rights, or if it's protecting their interests, I think so long as they are humans, they should be afforded proper legal protection, and they would also be bound by the law. And therefore, well, in reality, for a person of a third gender, if he or she come, or if this person comes to file a complaint with us, we will deal with that. All right. Both sides also, well, there are pros and cons about writing that in. So, what's your inclination? We believe that the most desirable way out is to use a gender-neutral reference. But if we are just looking at the sexual harassment provisions, we believe that using a gender-neutral reference would make it easier for everybody to understand, because this protection makes no distinction between people of different genders. And of course, the DFJ would say that if we do it in a very confined manner, then there would be inconsistency with regard to other pieces of legislation. We understand that. But then, in striking a balance, my current view is that I cannot see that if we just changed it to a gender-neutral reference in the sex discrimination ordinance, other than being inconsistent with other pieces of legislation, whether there might be any legal implications in terms of the protection to be afforded to the persons concerned. I am not in a position to make a judgment yet. Next, Helena Wong. Madam Chair, I'd like to listen to the EOC's comments on what follow-up action is needed. Well, in the first session, I've already said that the Association for the Advancement of Feminism came here to tell us that policemen were sexually harassing the protesters while they were on duty, and according to the administration, that's against the law, because this ordinance also regulates police or government employees, including policemen. So, have you taken any action in contacting the police force to ask them if they have specific guidelines in regulating police officers when they discharge the functions as to how they should comply with the law, or avoid any such complaints arising from the discharging of their duties, because there have been some allegations that male police officers would bear hug female protesters. So, what's your specific response? Dr. Ju? Thank you, Ms. Wong. Well, as soon as the EOC was set up, we conducted some training sessions for the discipline services, including the police force. We also asked if they had any internal guidelines on sexual harassment. As far as I am aware, they introduced it as early as 1999 and year 2000. With regard to the Civil Service Bureau, they've been maintaining close liaison with our training team. We've been organizing training sessions for civil servants, so we have done something in that respect. As regards the specific incidents involving policemen, it might be a male police officer bear hugging a female protester. It depends on how the law operates. Well, under the SDO, we have this complaint-oriented approach. That is, if there is no complaint and if nobody is there to give evidence, then we will not be able to deal with that, because we are not, we have no way to tell whether or not a specific female has been sexually harassed. But then where there is a complaint, we will have to look at the definition of sexual harassment. We also have to understand this. That is mainly we're referring to certain sexual acts which will be defined as sexual harassment. If we are talking about a very chaotic situation, I don't know whether or not it might be interpreted as a sexual act. We don't know what's happening on the ground and what's the purpose and what's the response of the parties concerned. And there can be a wide variation of the circumstances and how they can be interpreted. And that depends on the evidence or testimony of the persons involved. So that's a pretty complicated issue. Madam Chair, I hope that the EOC will not just be telling us that in 1999 and year 2000 you talked to the police and they had already got guidelines in place, but then it's been in place for so many years. Is it time for you to take it up again with them? Yes, they might have guidelines, but then if they have never enforced it, if they have never taken that very seriously, for example, there can be different reasons. For example, there were not enough female officers around, or it's a chaotic situation. It's difficult to tell whether or not it's a female or a male, or if the protester was just hugged for a few minutes and so on. So there is no way to be sure that the policeman would follow the guidelines. So the EOC should have taken this up with the police, whether or not they have the guidelines. It's not just about whether or not they have the guidelines, it's about whether or not they have given sufficient instructions to the policemen to follow the guidelines. Well, for different terms of chairman of the EOC, they have taken it up with the enforcement agencies, including government departments providing social services and so on. We have maintained regular liaison with them, and I understand that Dr. Jockey would be meeting with the police within the next few months to see specifically how they're enforcing the guidelines, and if members think that we should take it up with the police force, well, next time around when we meet with them, we will talk to them as to how they enforce this guideline. Yes, we should follow up on this, and we should also find out more. All right, any other members who would like to exchange views with the EOC? Yes, Mr. Poon Siu Ping.
Madam Chair, the EOC has had a survey of the air hostesses. 27% complained they have been sexually harassed by passengers. And this bill covers many other industries as well, say, for example, catering. Now, the EOC will be responsible for enforcing the law. So has the EOC assessed how many cases of complaints will be received? Not all 27% who have had the experience would come forward to complain, but I'm sure the enactment of the bill will have a bearing on your manpower. You'll see for flight attendants 27%, for students half of them have faced sexual harassment. The figures are quite alarming, but then for those that will be willing to come forward to complain, well, the figure or the ratio is low, maybe not even 1 out of 100. So the implications on our resources cannot be certain. But of course, upon enactment of the bill, if it is to increase the number of cases drastically, then we have to think about the resources. Well, maybe owing to the culture of Chinese, few people would come forward to complain. We've covered the educational sector, flight attendants, catering. Maybe we want to cover the sports sector as well. All right, thank you. Any other members wishing to ask the EOC questions for the first time? No, then second round. Raymond Chen, 3 minutes. Thank you, Madam Chair. Few people have come forward to complain. I think this is because what you get in return is small. The EOC provided legal assistance to 16 sexual harassment cases between 2009 and 2014, and a total of $187,000 was awarded as compensation. Would it be because of the small size of the compensation and so few people would want to take up the matter? And then in paragraph HA, 136 cases were successfully conciliated. Would it include compensation? Can you give us the information? Well, it is a matter of a civil case. Sometimes an apology can resolve the problem, or reinstatement, or there may be a financial compensation. Or in some other cases, the company is required to draw up new policies to stop this from occurring again, or a pledge by the offender to pledge not to commit the same again. So I don't think we should use the size of the compensation as the yardstick to measure we are successful or not. I think it's a matter of whether both parties are willing to come to a conciliation, and whether the victim feels that he is happy with the end to the matter. Yes, maybe we can't always be talking about the dollar sign, but then it's still an indicator. What about the largest amount of money awarded, and what is the smallest amount? Yes, if I may try to supplement. 136 cases were successfully conciliated. I think the total sum was about $5 million. It all depends. I just want to explain further. For sexual harassment, it is a civil claim. As Mr. Chen has said, you referred to penalties. In fact, it's not a penalty, it's a matter of damages. It all depends on the facts of the case. Sometimes other than sexual harassment, the victim may lose his job and then he may suffer financially. And in this case, the amount of compensation may be large because of the high level of salary. It can be 2 or 3 months salary, or even up to 6 months salary. And then there is also another form of compensation. I think the case law is that in a Chinese restaurant, as a result of the vicarious liability, a cashier has to be compensated for suffering from sexual harassment. And the court's consideration is that the starting point should be $80,000. It all depends on the facts of the case. And I remember that not too long ago, in another court case, the judgment was $100,000. And sometimes we have started legal action, but then the case may be settled out of court with compensation ranging between $20,000 and $50,000. It is difficult to be specific. So it is quite unlike the criminal offenses when you can be clear about the level of penalties or the term of the imprisonment. Or in civil cases, it all depends on the facts of the case. Next, Helena Wong. If I may talk about the paper from the administration, that is follow up on issues raised at the meeting on the 23rd of July 2014. I understand that we are going to deal with the case of employees working on ships and aircrafts registered in Hong Kong, but when the ships and aircrafts are outside Hong Kong. What about the employees of the cross-border tourism industry? Can the administration explain this matter? What about tour escorts leading two groups to mainland by land route? Of course, if they they fly to the destination, it will be covered in the case of Hong Kong registered aircraft. But then for tour escorts, we have got 19,000 members in the sector. So what is your recommendation? Does it mean that you don't intend to cover that? Maybe administration first? Thank you, Madam Chair. For the point made by Dr. Wong, currently, if you take a flight or if you travel by ship, and if something happens in Hong Kong, of course, it's subject to the laws of Hong Kong. When you go to another place, then you will be subject to that jurisdiction, or you can take it up when you return. Now, there may be a sort of a window, a gap, and now the bill will address this one as well. Now, you may want to know whether train travel and land transport would also be covered. You want to know why we are not addressing this. Well, there won't be any gap in terms of the jurisdictions involved. There won't be any gap at all. So for the 19,000 tour escorts, if they go to a foreign place, go to another place, if something happens, they can always turn to the authority of that jurisdiction for help. And in the annex to the paper, in response to members' requests, we have given you information on the mainland against sexual harassment. And in fact, it is a criminal offense, and there are different levels of penalty. So for the tourism industry, for tour escorts going to the mainland, if they encounter sexual harassment, they can turn to the mainland authorities for help, and then they can also get some support there. You see? Do you have anything to add to the reply to Dr. Wong's question? When the tour escorts are outside of Hong Kong, of course, they are given the safeguard on board a flight or a ship registered in Hong Kong. But then if we want to extend the safeguards to places outside of Hong Kong, then it means that we are trying to exercise our jurisdiction in a foreign place. It will create a lot of difficulties. All right. If there aren't other policy-related questions for the EOC and administration, then I think we can move into the cross scrutiny of the bill. But before that, I would like to thank Mr. Poon and Mr. Chu, Dr. Chu from the EOC for attending today's meeting. Thank you. We'll now have the cross scrutiny of the bill. Before we start, I would like to invite the administration to explain the individual provisions. Please also take a look of the marked up copy. You find it in paper CB bracket 2 2096/13 to 14 bracket 01. Yes, administration, please. Yes, please take a look of the Blue Bill, Sex Discrimination Amendment Bill 2014. For the purpose of the bill, this is to amend the Sex Discrimination Ordinance Cap 480 to render unlawful any sexual harassment against providers or prospective providers of goods, services, or facilities or services, and to apply the provisions relating to sexual harassment occurring in offering to provide, seeking to provide, providing goods or facilities or services to sexual harassment of this kind occurring on local ships or aircraft outside Hong Kong. You'll find the details in clauses 3 and 4 of the bill. Clause 3 says that this applies to Section 40, and we are going to add Section 1A to extend the offense to persons providing or seeking to provide goods, facilities, or services. And then for clause 4, it says that in section 41, we would like to add 2 new subsections, that is subsection 6 and subsection 7. The purpose is as follows. That is, we want to apply section 41 and 41A to sexual harassment that occurs outside Hong Kong, but occurring on a ship, aircraft, etc., registered in Hong Kong. So if you've got any questions, feel free to raise them. So first of all, we would like to add 41A to section 40. So members, any questions? Ms. Sithole, Madam Chair, what about the government's position? Now the EOC, deputations, and a lot of members are saying that we should have it gender neutral in terms of the drafting. What is the admin's position? Now, of course, it's easy to make a revision to your bill, but then it will have a lot of implications. Would you really, would you just rely on Cap 1 so that when reference is made to one sex, the other is also included or covered as well? Mr. Lau, as Sithole has said, if we start to make changes in one place, it will have implications elsewhere. I think we already talked about our position last time. We want to maintain the status quo.
Any person going to the EOC will be protected. And second, if we were to change it, then it will have far-reaching implications. That's why we might as well wait till after the consultation is completed and EOC has come up with a recommendation. Well, Madam Chair, let me reiterate my stance. That is, when we try to come up with this amendment bill, if we were to move an amendment to make it gender neutral, it's not difficult at all. But then I personally think that I would not just be adding this to the newly added clause and also the newly added 41. So we will not just be changing the 2 amendment provisions, that is 40 and 41, because there are other provisions which might also be affected. But then by then you would also accuse us of going beyond the scope of this bill. And even if we have done that, you would still disallow us, and then the chair would also listen to your advice. That's why we'd like to reiterate our stance. Well, it's not true that the chair would not listen to other people's views. I know you're very experienced. I'm fair and impartial. If I think that what you said is correct, then I would take it up with the administration. Well, Madam Chair, when you're a chairperson, you are really very good. I think it's a lot better than you were one of us here in the floor. Okay, I would very much like the administration to move the amendment. Well, it's not that we don't want to move an amendment ourselves, but then there might be administrative issues, and you can always object to our amendment, and then the President would definitely take heed of your advice in rejecting our amendment. So I hope that after the EOC has completed this consultation, please remember to add in this gender neutral reference when you review the legislation next round. Can I put it to the administration? Is it only the in the SDO that you would use the feminine reference? How about other pieces of legislation? Do you always use gender neutral reference? You're referring to other ordinances outside of the SDO. There is no way that we can answer your question because there are simply too many. Well, let me finish. All right, just on the SDO, if you just changing this provision without changing the other provisions, that's undesirable, and it's also inconsistent. That's why we are not going to do it. We also agree with what Ms. Ho just said. it's not just about the difficulty of moving the amendment. It has other implications. And I'm sure Ms. Ho understands that. And if Ms. Ho wants to move an amendment, that's the right of the member. As to whether or not the President would approve it, I think he would act in accordance with the rules of procedure. So it's not for us to comment, but then our stance is very clear. We'd like to defend the current approach. Well, Madam Chair, our difficulty is that we only get Section 40 and 41 of the SDO, and then for 1 to 39, and the rest we don't have a copy, and therefore you will find it easy to accuse us of going out of the scope. And we also don't want it to be confined to clauses 40 and 41. And then for the rest, under the same ordinance, they will still have gender-specific references. So even within one piece of legislation, if there are different approaches when it comes to gender reference, that's not good at all. So, Undersecretary, please do not put this into my pocket. I'm not going to move it because technically I cannot do anything about it. Undersecretary, I think Ms. Ho knows the situation well. There is no need for us to argue about it. We all understand the situation. But I think we all have to bear this in mind. Alright, we have many employees who would like to have this passed, and if we can enact this as soon as possible, then we can afford protection to them as soon as possible. I'll not be making life difficult for you at all. You don't have to worry about that. Yes, Ms. Ho. In any case, we will only be working on sections 40 and 41, and for the rest, it's outside the scope of this Bills Committee. Mr. Raymond Chen, I understand that the administration stance is that it's not going to change the gender reference in this bill. But then from what we have heard from the EOC, even for a gender-neutral person approaching the EOC, the EOC would still help this person. But then according to the administration, we were told that under Section 7 of the IGCO, it says that for person of any gender, the person will be protected. So would it mean that the EOC would like to adopt a humanistic approach so that even for a person without a specific gender status approaching them, the person would be protected? So can the administration tell us more definitively as to whether such protection would be afforded to the gender-neutral person? Well, under the SDO, while it was drafted, it assumed that all persons can be categorized into either male or female. So it's drafted on the basis of a bisexual or heterosexual nature of society. And if a person of a masculine gender needs to be protected, then technically we will have to be able to distinguish which gender the person belongs to. And in Hong Kong, all along, we do have this category of people who are gender neutral. And yet on their ID card, they would always be defined as there would always be this gender entry of either a male or female. But then for a foreigner, the person could also be subject to sexual harassment. For example, an Australian could have a gender entry of X on his ID card or identity document. So will that person be protected in Hong Kong? Well, that's the problem. Well, in some overseas countries, that they have a new category of gender which is not existent in Hong Kong, and as the EOC said, there's no precedent, but then they would still accept such complaints. So they have made it clear that if there were such complaints, they would be prepared to accept it. And under the circumstances, they would be afforded protection in civil cases. In other words, if they seek damages in a civil case, they could get damages, they could get a lawyer, and then they could also file complaints with the EOC, and then they will see if damages can be awarded to them. But then under the way it is drafted, do you think that can be dealt with? Do you think that a gender-neutral person can be protected? Well, everybody will be protected. That's the intention. The original intention is either to protect a male or female. Well, they are not here now, but then they have already stated that they would be prepared to take on the complaints. Yes, I know that the EOC would accept the complaints, but then I'd like to know, without any change to the wording, do you think that there would be legal basis to protect these foreigners whose gender identity is X on their ID documentation? So it's just a yes or no answer. I don't think that's a very difficult question to answer. So can you be more specific? Monsieur, can you be more specific about this? Alright, if they quote this law under the existing legislation, so the person has to be of either sex, and then the person has to be sexually harassed by somebody from another gender. And then for gender neutral person, we are talking about persons who can be defined by a doctor. Alright, we are talking about foreigners with a gender entry of X on their travel document. So would they be protected? Alright, if the gender identity is X, not M or F, would you accept their complaints? It's not about the EOC. Will this law be able to deal with such cases involving foreigners with a gender entry of X? The EOC said that they would be able to deal with that. We would like to listen to the DFJ's advice. Well, they would institute a civil case, and then they would have to prove that they would fall under the scope of the law. I think you will have to make it clear. Alright, if a person with gender X comes to you, then you will have to tell this person whether or not this person will be protected by this ordinance. So it's a very simple question. Can somebody from the DFJ answer this question? Madam Chair, I'll attempt to supplement on it. Well, in the laws of Hong Kong, we only, in principle, recognize either male or female. That's why for persons from overseas countries coming to Hong Kong, well, the persons will either have to be a male or female. So in any event, the persons will be protected. Well, how come you are saying that if the person is not a male, then that person must be a female? How can that be the case? They can always have an entry of X. Alright, even if they carry a passport stating that they are of gender X, as soon as they come into Hong Kong, under Hong Kong's laws, they would be either recognized as a male or female under the laws of Hong Kong. In those circumstances, in any event, they would be protected by this ordinance. Can we ask them to give us something in writing to confirm this? Yes, you can give us a written reply. That is, this person of a gender X would have to agree under which gender this person is filing this complaint before he or she can be, before this person will be protected under the law. Is that the case? So this person will have to first declare whether or not this person is a particular gender before the person will be protected. As this is a civil case, it's a tort case, and therefore the plaintiff has the responsibility to prove that the person is a victim. Okay? In answering questions, the DFJ is always very careful. That's why you will not be able to get anything out of them now. But then if it's a, alright, if this is a person, then the person will be protected. But then let us deal with it this way. We hope that they will know this. That is, in some countries, assuming that in their identification or identity document, if the entry is not is neither M or F, then what if it's a third gender? Will they be protected? Because it's not just confined to a particular country. There might be other countries which are doing the same. So can you give us something in writing? Yes, Assistant Secretary. Let me explain a bit in order to address members' concerns. Under the SDO, so it's either a male or female. That's the interpretation. But then according to the EOC, their attitude is that so long as that person is a human, they will take on the complaint. But then Mr. Chen was asking, well, the EOC already explained that there was no such precedence. There was no person of gender X going to them to file a complaint. But then they already promised that they would take on the case. But then members' concerns was about the recognition of a third gender and how that would be dealt with. And the Secretary for Justice is now chairing an IWG, an interdepartmental working group with regard to gender recognition, is now looking into the issue, and is also in relation to laws in relation to the rights and interests of transgenders, and they would also be looking at other laws in other jurisdictions and related policies and so on, and they would come up with recommendations. And after looking at the gender recognition mechanisms elsewhere, they've also noted that in some overseas jurisdictions they do recognize the third gender, and also there would be regulations governing the third gender, and the IWG is looking into how this should be dealt with. They haven't come to a conclusion yet, so that's as far as I'm aware of. So we have to ensure that this law is enacted, and before any new cases arise, the law would be revised and reviewed. Okay, we hope that the DFJ can respond to our questions. In any event, this law is to protect the people in Hong Kong. We would like it to be implemented as soon as possible. We hope that in a not too distant future that could be dealt with. Ms. Sito, yes, I'd like to ask the administration. You've got this administrative arrangements in place. Well, if somebody is harassed, as this is a civil case, you're actually placing the onus on the complainant. And then it's for the person to prove if he's a male or female, and there is no question of a third gender. And let's say at the point of immigration, during our day-to-day administration, you also require the person to fill in the gender. And what if the person fills in X, then how are you going to deal with it? The immigration department cannot say that, well, as the three-man team chaired by the S4J has not completed its work. You will have to be prepared for the third gender to be entered into the documentation. So how are you going to deal with that? Yes, you will have to look into it. Or maybe you can give a response. Well, the DFJ will have to answer the issue of the SDO. At the point of immigration, we will try to find that out from the Security Bureau, and then we will give you a written reply. Because at the point of entry, well, for the visitor coming to Hong Kong, the person will have to fill in this entry form. So you will have to allow for somebody who declare that they are of a third gender or gender X. Mr. Kenneth Chen.
Madam Chair, we are willing to see this bill going back to the LegCo ASAP and have it enacted. I'm also concerned about the various issues raised by members. Of course, you can give a very technical reply in relation to the reference to the gender, whether male or female. And then the DOJ's colleague had a hard time in giving an answer. Now, we are finding ourselves in a sort of difficult position. Of course, in terms of a civil case, you need to have the burden of proof, and then someone may be aggrieved in trying to prove whether the case or the law applies to him. And this is exactly against this background that we want to ask such questions. Does it mean that a person will be forced to JR the case and citing the basic law and proves that he has been discriminated against, even though he doesn't belong to either of the gender? It seems that the administration would sit idle and do nothing about it. I think when you give a written reply to us, I hope you can say more. I don't think you can really dodge this issue. I'm also very concerned about this. All right. Yes, any reply? No need? Then anything else on the bill? Dr. Helena Wong. On behalf of the DP, I would like to say that we support the early enactment of the bill, and we hope that after that, for the amendments of other provisions of the discrimination laws, I hope the administration will finish the job ASAP. We are not going to filibuster as far as this bill is concerned, so you don't need to worry. All right. Administration. Now, we haven't got other questions. So when would you expect to resume the second reading debate? We intend to resume the second reading debate on the 3rd of December. In other words, on the 21st of November, I have to give a report to the HC. If members would like to move any amendments, then the deadline for giving notice would be 24th of November. Any other questions? If not, then meeting is ended. Thank you for your attendance.